Hello, good morning, everyone. And as Mark said, welcome to the first Mills and Reeve in-house in focus session of 2021, which is on how to avoid contract disputes. We have over 350 people registered, and it's great to see so many of you today. A bit of housekeeping. The session is being recorded and a recording will be made available in the next few days. Also, if you have any questions, please do ask them in the Q&A function, and we will answer these at the end, time permitting. So you are aware, it will only be Mark and myself that can see your names in the Q&A function, so we won't be reading out your names. We've also had questions emailed in advance, so any questions that we do not have time to answer today, we will follow up with afterwards. The purpose of today is to talk about dispute prevention techniques and what parties can do to avoid full-blown disputes. It tends to be that uncertainty will generally cause disputes. It is therefore a particularly topical issue at the moment in light of the political uncertainty and COVID-19, not to mention all of the other usual factors we normally have and the general global uncertainty. Sometimes disputes are unavoidable, so we will also discuss what parties should do and not do in order to put them in the best position possible if a dispute arises. As they say, hindsight is 20/20 vision. As a commercial disputes lawyer, we have the benefit of hindsight as we are often advising on the impact of contractual wording, emails, WhatsApp messages, and other events after a dispute has arisen, with the benefit of knowing actually what has happened and seeing how a court interprets such wording and events. Today, we intend to cover the following: steps you can take to avoid disputes occurring, steps you can take to avoid a dispute escalating into litigation, the do's and don'ts if a dispute appears unavoidable, alternatives to litigation, and the key message today, the key takeaway, is that you should be starting early, be proactive, and stay organized. By way of introduction, I am Doug McDonald and a partner in our commercial disputes team, advising on these issues on a day-to-day basis. Today is a double act between myself and my colleague Mark Davison. I will now pass over to Mark for him to introduce himself and talk about the importance of starting early.
Thanks, Doug. My name is Mark Davison. I'm the head of Mills and Reeve's International Arbitration Practice based in our London office. So we'll kick off by looking at some tips of what you can do at the very outset in order to try and avoid disputes later on. Some of the points that we're going to cover are probably steps that you're already taking as a business, but hopefully they'll act as a useful reminder. Also, I think Doug and I both appreciate that many of you on the call today are from large organisations, and generally it's your commercial and operations colleagues who run contracts and projects, and that the first time that you hear that an issue has emerged is when already a full-blown dispute has emerged. So Doug and I will try and give you a few tips about what you can do with your commercial colleagues in order to try and help them avoid disputes. So the first point I want to make is that preventing disputes isn't just about what happens when a contentious issue emerges. It starts at the very beginning of a commercial relationship. So there, just in respect to the first point there on the slide, there are steps that you might actually want to take even before you start discussing commercial arrangements with a counterparty. So the first option is to look at whether you can take due diligence steps on your counterparty to ensure that they can actually deliver what they say they can deliver. If you're going to be paid for a service, consider whether or not you should check company credit reports for any public history of late payments or payment defaults. I've done quite a lot of work in the Middle East, and some clients there used to work with private companies in order to do this, given that public information is quite difficult to find in those jurisdictions. You might also want to check whether there are any judgments against your counterparty as well regarding their performance of contracts. That might actually just give you a flavour as well as to how litigious they are. So in respect to the contract itself, I think, as we all appreciate, most people don't want to end up in litigation, and the majority of contracts don't actually end up in dispute. But obviously, you and your commercial colleagues can try to start avoiding disputes from the very beginning with the contract itself. So when you're drafting agreements, it's well worth talking with your commercial and operations colleagues that are going to run the contract or enter into that commercial relationship, to just think about what it is that might actually end up in dispute on that particular arrangement or project, and just make sure that that's provided for within the contract. So when you're looking at what obligations the parties are supposed to perform, just make sure that they're clearly defined so that there's no dispute or misunderstanding about this later on. I appreciate that as an in-house legal team, how incredibly busy you are, and that often you'll rely on precedents in order to enter into contracts. But just actually have a think about whether or not actually the wording of the particular performance obligations is clear in respect of this particular counterparty that you're dealing with. A particular good example of this is about reasonable endeavours clauses. So namely, a clause which requires a party to use a certain amount of endeavours to do something. The disputes around endeavours clauses are always about whether a party has actually expended enough effort to do something. And principally, they're about what a party has spent in order to provide that amount of endeavours to do something. And those disputes could have been prevented by just actually setting out what the parties' expectations were in the contract. If you're dealing with contracts concerning a project or medium to long-term obligations, you might actually want to consider whether there's regular monitoring, reporting, or meetings between the parties. These are particularly common in construction and IT projects. And I always find, I'm sure Doug's the same, that the advantage of these is that they often flag up issues before they become too late, because they're discussed within those regular monitoring, reporting, or meetings. And because those projects are collaborative in nature, it's usually in everybody's interest to try and get an issue resolved before the issue derails a project. One query we've received before today was about what parties can do about the ongoing lockdowns, effectively preventing performance under a contract. I think Doug and I's sort of view is that obviously the first point of call will always be to just actually have a look at the force majeure clause, or whether there's any other contractual clauses that might assist you within the contract. Obviously, if you're entering into agreements at the moment or seeking to amend agreements, then you should actually look at your force majeure provisions just to ensure that they cover pandemics and government acts, just to ensure that you've got the best chance that that force majeure provision will cover any future lockdowns. Even though it may be foreseeable at the moment that there might be future lockdowns here in the UK, that will not necessarily prevent you from being able to rely on a force majeure clause. But I think within a force majeure clause, what I would say is it might not actually be the best way forward. And I say this for three reasons. First, obviously, if you're relying on a force majeure clause at the moment, a party has a duty to mitigate the impact of that. So the party that's relying on the force majeure clause has a duty to mitigate the effect of what they are saying is preventing or hindering their performance. Second, what we're seeing a lot at the moment is that parties are actually claiming force majeure when it's not actually the pandemic itself or the lockdowns which is preventing or hindering performance. All the pandemic has actually done is just made it more difficult or expensive to perform. And unless it's exceptional, the courts have generally said that a force majeure clause can't be relied upon in those circumstances. And then very finally, I think as many of us will know, that most force majeure clauses actually allow a party to terminate if a event carries on for a certain period of time, which prevents and hinders performance. So just think about very carefully whether you actually want to rely on the force majeure provision if it's not going to be resolved within a certain period of time, and it gives your counterparty the option to terminate the agreement. So an alternative to force majeure clauses at the moment is that you might want to try and agree up front whether the performance requirements under a contract should be amended if there are future lockdowns. Obviously, that will be dependent on the type of commercial arrangement that you have, but Doug and I will be very happy to talk to you about that if that's something which you're considering at the moment, depending on what your particular circumstances are. I think one thing I'll just add is that obviously for us in the UK and with the vaccine being rolled out, God willing, hopefully this is the last lockdown that we'll see here in the UK. But certain jurisdictions may have rolling lockdowns for at least the remainder of this year and maybe for a few years to come, depending on when they're able to get access to the vaccine and get that rolled out within their particular jurisdictions. So it's just something to bear in mind when you're dealing with counterparties who are based in other jurisdictions outside of the UK. Another way that you can actually try and start taking steps to avoid full-blown litigation is actually within the dispute resolution clause itself. So the most common form of dispute resolution clause that Doug and I see is that parties can go straight to litigation or arbitration if there's a dispute between the parties. But you don't necessarily have to have that, though. And if you want to ensure that there's at least some commercial discussions before a party can go to litigation, you could incorporate what we call a tiered dispute resolution clause. And basically what a tiered dispute resolution clause is, it provides a contractual requirement, a condition precedent, essentially, for parties to take certain steps before they're actually entitled to commence proceedings. So most commonly, the most common dispute resolution clauses that certainly Doug and I see are for structured meetings of specified individuals to meet to try and see whether they can resolve a matter. Usually the contracts in those cases provide a time limit such as 14 or 30 days before a party can then commence litigation. Alternatively, you might want to include a mandatory provision that parties try and resolve a dispute by mediation before proceedings can be considered. Before proceedings can be commenced. That's not necessarily going to be suitable in all cases, but it's certainly something that you might want to consider in your contracts. Certainly my view of mediation is that it's a positive process, and more often than not, I find that it resolves disputes, or it certainly brings out issues out of the woodwork that you can then work through, which you might not necessarily find out about until later in the litigation process. What I would just say very quickly, though, is if you're going to have those types of tiered dispute resolution clauses, is it might be just worth having a carve out within that clause, just saying that if you need to go and get injunctive relief, that you're able to, just so that there's no uncertainty about that within the contract. The very final point I just want to make about contract drafting, and it's a point that I always make when I'm talking to clients about dispute resolution clauses, but it's always just to have in the back of your mind, how are you actually going to be able to enforce any judgment that you get against your counterparty, especially if you're dealing with counterparties who are based overseas. So take, for example, if you're dealing with a counterparty based in Kuwait or Saudi Arabia, it's going to be difficult to enforce an English court judgment there. So in those circumstances, arbitration might provide you with a better chance of enforcement than a court judgment. And the reason why that's important for dispute avoidance is because obviously if your counterparty is in breach, but they actually know, looking at the dispute resolution clause, that it's you've got very little prospect of being able to enforce a judgment against them, then they might not actually take steps to try and resolve the dispute commercially. In respect to the third point there on the slide about contract management, obviously once a contract has been signed, obviously please don't forget about it. And as in-house legal teams, you should encourage your commercial and operations teams who are running the contracts to regularly review them to ensure that obligations are being complied with and that nothing is missed. Again, I appreciate that for those of you who are in large organizations, it's just not simply possible for you as an in-house legal team to keep an eye on every contract. So one option you could consider is actually whether you set up annual audits of key contracts and relationships to ensure that everything is still on track. So speak to your different commercial and operations teams within your business and sort of say, what are the 5 key relationships or contracts that you have? And then perform an audit on those to make sure that everything is on track. Another point, as some of you will sort of appreciate, that some commercial relationships develop and expand over time, and parties can actually still be operating on the basis of a simple agreement or memorandum of understanding that was entered into years ago. So as part of that audit process, you might actually want to consider whether those contracts or MOUs need to be updated. Obviously, as you'll probably appreciate, that it's better to try and agree amendments to a contract when everything is rosy between the parties, rather than later on when something has become contentious. And then just in respect of the final point there on the screen about record keeping, I'd certainly encourage you to encourage your commercial colleagues to ensure that good records are kept about what's been performed and what decisions have been taken. As Doug talked about with 2020 vision, disputes are always looked through a retrospective prism, and often people's memories change over time. So courts generally prefer a contemporaneous record taken at the time of an event that has occurred, rather than try and rely on somebody's memory a couple of years later, especially if that conflicts with what the other side is saying. So Doug is now just going to talk about what proactive steps you can take during the life of a contract.
Thank you, Mark. The starting point, whilst obvious, is to establish the contractual position and what you are actually required to do. If a dispute is on the horizon, you should review the relevant contracts, but also the key documents. Especially for a longer term relationship with the counterparty, you need to review any change control notices, amendments or variations, as well as key correspondence. And for example, if there are project management meetings, then the minutes from those meetings. If you are experiencing difficulties, then do any of the terms excuse performance? And if so, what are you actually required to do to obtain the benefit from those clauses? As Mark was saying, I mean, I think now more than ever, when it comes to entering into new contracts, boilerplate clauses such as force majeure clauses and dispute resolution will hopefully get the airtime that they deserve when entering into new contracts. One thing that I see time and again is often that one party has not delivered in some way, and it is an ongoing issue. The general unhappiness between the parties continues until a point at which a director of the other party will then tell an in-house lawyer, normally, or a contracts manager, that they have to go legal, whatever that might mean. Especially at that point, and I appreciate that in large organizations, as Mark has touched upon, the in-house legal team may not be aware of certain contracts or even a dispute until this point. But it is so important to commit sufficient time at this stage to objectively analyze and consider the legal position. At one end of the scale, it might appear to be as simple as a non-performance, such as non-delivery of a product. But does that actually give you the right to go legal and terminate, no matter what your business colleagues are saying? Whilst common sense might appear to suggest that you could, is there an obligation, for example, to provide the other party with an opportunity to remedy the breach? Or is it an old and ambiguous contract where it's not entirely clear what you can and can't do? At the other end of the spectrum, it may be more complicated. For example, an outsourced software contract where it will not be clear whether the required functionality has been delivered according to the contract. Again, it is so important to commit time at the outset to objectively challenge your business colleagues at that stage. For example, your colleagues may insist that the software platform does not do what they were promised it would do because they were expecting a plug-and-play system. But no matter what they're expecting, what does the contract actually require the provider to deliver? Can your technical or business colleagues actually point to the contract clause or the specification that has not been delivered? Or have there been so many formal and informal variations along the way during the relationship that the contract actually no longer reflects the reality of the situation? Rather than launching into a full-blown termination letter, unless you are confident in your position or you've instructed external lawyers to do it, again, just take time to objectively challenge yourself and your business colleagues against the backdrop of what is contained in the contract. Whilst this may sound time-consuming and slightly awkward in terms of challenging someone internally, it is a lot less painful than a full-blown piece of litigation or even just a protracted commercial dispute. Involving commercial disputes lawyers early is also far more cost-effective. I do appreciate, Mark and I both appreciate, there is a balance between being an agile in-house lawyer providing legal and commercial advice to the entire organization, and you're balancing that against the need to avoid formal disputes if possible. not to mention the valuable commodity of time that might not be available to anyone. As a practical tip, and if you don't already, perhaps you could have a template email that you can send back to your colleague each time that a dispute is brewing, that will ask for the required information at the outset, not just the contract, but also the key correspondence, any minutes of project meetings where the relationship may have been varied formally or informally. That email could, for example, also include a few initial comments in terms of what your colleagues should and shouldn't do. For example, preserving documents and being mindful of communicating with the other party. Again, please do get in touch if you'd like to discuss this further. On the slide there's a bullet point to say about understanding the dispute cycle. Often disputes are left unresolved until it's too late. Again, if there is a dispute on the horizon, reach out to your counterparty to try and reach a commercial solution or compromise. It might feel that a resolution is not possible, but it is often easier to resolve a dispute when there is still some relationship existing or before the parties have been left to stew for too long. You should consider whether to make those approaches on a without prejudice basis, and this should be done in parallel to the review of the legal position I've just mentioned. A key tip here would be to try and educate all of your colleagues, if you haven't done so already, within your organization as to the actual meaning of without prejudice, and make sure that they know that this does not mean you can put it on every email and then say whatever you want. We find that people often use without prejudice in the same way as no offense, but, or with respect, but, and then say whatever they want, which can and often will compromise your legal position further down the line when a formal dispute arises. In terms of contract notices and limitation, consider if your contracts require you to serve any contractual notice and whether these need to be served within a particular time limit, which, if not, may prevent you taking steps later on if they have not been served. If there is a requirement within the contract, a court would expect you to comply with it. The court's starting point and finishing point is normally the contract, so make sure you understand what is in there. But for example, IT contracts will often require notices to be provided within a certain period of time, within becoming aware of the event, but also general force majeure clauses quite often have a notification requirement. And again, a court will enforce those requirements. I'll now pass back over to Mark, who will talk about getting organized if a dispute is unavoidable.
Yeah, so I'm just going to try and cover a couple of tips of what you should do if, as Doug says, it just looks inevitable that a dispute is going to happen and there's a substantial risk that that may escalate into formal proceedings. I think, as Doug said, certainly try and encourage you to encourage your commercial colleagues to tell you at the earliest if there is a problem. Obviously, it's so much better, it's so much easier to try and get on the front foot if you know that a dispute has emerged early, rather than be on the back foot later on when it's all got out of control, so to speak, and you're then drafted in to try and clean up the mess. In respect to just some top tips of the do's, if it looks like a dispute is unavoidable, the first point there, again, is enforcement. As I said before, when you're drafting a contract, you should always have enforcement in the back of your mind. And the same is obviously relevant for when a dispute emerges. So before embarking on any litigation steps, just step back and consider your counterparty and how you would enforce any judgment against them. In particular, has their solvency position changed over the lifetime of the contract so that actually they're now in an insolvent position, to which case actually is there any merit in pursuing in the litigation? Equally, are they based in a jurisdiction where enforcement may be difficult? In respect to witnesses, obviously you should actually start thinking about what witnesses you'll need to prove your case, especially if your organization is about to embark on redundancy processes, or you know that a key witness is looking to leave the business. Try and look at what steps you can take with the commercial side of the business to keep them within the business. Doug and I both know that cases live and die on witness evidence, and because there's no property in a witness, it can often be hard to get evidence from an employee once he or she has left the business. And obviously, if they've left in a redundancy circumstances, there is a risk that actually they might be hostile towards your case. Doug touched on documents before, but obviously once you know that a dispute is looks like it's unavoidable, sorry, just go back. Once you know that dispute is unavoidable and it looks like the litigation may occur, then obviously start considering what documents you need in order to establish your case, and just make sure that they're not deleted or destroyed. It's a requirement under the civil procedure rules anyway that parties take steps to preserve relevant documents once a dispute emerges. So speak to your IT team in order to make sure that data of key custodians isn't deleted. Speak to the key people involved in the relationship or the project which has become contentious to make sure that they don't delete any documents, whether that's electronic or hard copy documents, and maybe consider issuing sort of hold notices so that they know what they can and can't do. In respect of insurance, so you might actually just want to consider whether there's any insurance policies that you hold as a business which might assist you in the context of the dispute. And it's well worth discussing those with your brokers. But it's also well worth looking at the terms of those policies as well, just to see whether claims have got to be notified to insurers within a set period of time. A particular example might be business interruption insurance, although I think as many of you will appreciate, we're all waiting for the Supreme Court FCA test case decision to come out, which hopefully shouldn't be too long. Obviously, seeking specialist advice, as Doug touched on, it can be commercially prudent and cheaper to get the commercial litigators on board early, just so that you have a full assessment as to actually what your rights are, what weaknesses you have in your case, and what your options are. Appreciate Doug and I are often seen as commercial litigators as the Grim Reapers, but actually we're there to help try and provide commercial solutions as well to try and help resolve disputes. It's in everybody's interest if a dispute is resolved earlier on rather than later on. The point there about mitigation. So in the heat of the moment, I appreciate that parties can sometimes actually forget that they've got a duty to mitigate their losses. So it's just a quick reminder that's something to think about if a dispute has emerged. Are you actually taking steps to mitigate your losses? If you fail to mitigate losses, then a court might actually limit you later on as to terms of what damages you can recover. And then just very finally there about litigation funding. I appreciate many of you will know what litigation funding is, but I appreciate that your finance team might not be particularly delighted about the need to try and increase your legal budget to pay for litigation, or where cash is particularly tight, especially at the moment. And so you might just actually want to consider whether third-party funding could be used in order to try and fund the litigation or to remove the liability from your balance sheet. We're running a session on third-party funding in a few weeks' time, so if you'd like more information about how it works, what it is, and what options are available with third-party funding, then please do join us for that. So that's some of the do's if a dispute is unavoidable. Doug's just very briefly going to touch some of the don'ts.
Thank you, Mark. So you've heard what to do from Mark, and I'm now going to summarize some of the key don'ts. Don't terminate without considering the legal basis first, or without seeking external advice if required. Incorrect or unlawful terminations are a very rich source of work for litigation lawyers, as people so often get it wrong. As you will be aware, if you unlawfully terminate a contract, your counterparty may accept your repudiatory breach, and you then may be liable for damages. Generally, you cannot take back a termination. You also cannot reignite a contract that has been terminated. Don't just pursue legal remedies, you should also look at commercial solutions in tandem. This may lead to the best results, but always do them in parallel. You should try to avoid the situation where you are convinced that there will be a commercial solution, so you ignore the legal position and forget to protect your organization. From my experience, certain corporate providers or contracting parties are very good at making it look like they want to do a commercial deal, when in fact they are laying a retrospective paper trail to assist in a future claim, often with their lawyers inputting in the background into those communications. Letters such as, "We want to resolve it, but we are incredibly disappointed by your failure to follow the terms of the contract." Don't just assume that you can rely on force majeure type clauses for excusing performance under the contract. Check whether it actually covers the event and whether you are required to do anything, as we mentioned earlier. Force majeure is a clause that lawyers of today have probably not given much thought to until the start of last year, but it is a creature of contract, so it all depends upon the exact wording and not general principles. Don't waive privilege, and make sure that your organization is not waiving privilege, whether that be legal advice privilege, litigation privilege, common interest privilege, etc. I mean, it's a topic that we could talk non-stop about for a week. In any event, ensure that your organization is taking care when communicating internally. Litigation privilege only applies once a dispute is reasonably in contemplation, which means that emails, notes of meetings, and discussions with those involved in the project may be liable to disclosure, unless it can be shown that dispute was reasonably in contemplation. As a practical tip, please ensure that your colleagues do not undertake an early lessons learned type exercise where they document and outline everything that they did wrong throughout the whole relationship, unless it is covered by privilege. You might be surprised by how often we do see those documents. As an in-house lawyer, we appreciate that you are often moving between providing legal advice and providing general commercial input to the business or the organization. You need to be aware of when your communications are actually privileged and when they are not. It really is a minefield. So again, please get in touch if you do have any particular questions about privilege. But by way of example, be mindful that even a partial disclosure of information to the other party may be deemed to have waived privilege in a document or a wider group of materials more generally. It is certainly worth having privilege in mind from the very outset and taking practical steps so as to increase the chances of something being privileged. In terms of legal advice privilege, again, a topic in its own right, but just be aware, if your colleagues to be aware, that just copying in the in-house lawyer is unlikely to be sufficient to make it privileged. It must be for the purposes of obtaining or actually giving legal advice. We've mentioned there about not ignoring the civil procedure rules. There are certain requirements that I'm sure you're aware of under the civil procedure rules. There are certain key steps that you need to go through, which include providing the other party with sufficient information so as to understand the case it has to meet. Do not ignore them. Whilst you may not be in a situation or at a stage whereby you have to follow every step, it is certainly worth having them in mind and being familiar with them so that when you then do instruct external lawyers, you don't have to start the process again. I'm going to pass back to Mark now to tell you also why you should not ignore the government's guidance on reasonable contractual behaviour from May and June of last year, as well as the alternatives to litigation and arbitration.
Thanks, Doug. So just very quickly on the UK government's guidance, many of us will remember the guidance that they issued in May and June last year, which effectively encouraged contractual parties to act responsibly and fairly in the national interest in performing and enforcing their contract. So basically what the government was asking parties to do is to act reasonably with each other. It gave a list of examples within, I think it's paragraph 15 of the May guidance, which is well worth taking a look at. A question that we were asked a lot when it first came out was, is it enforceable? The simple answer is no. The guidance makes clear that actually it doesn't override any legal rights or obligations that the parties may have either under the contract or otherwise in law, custom or practice, including any rights that they may have under equitable relief. So you might think, why am I telling you about this? So, whilst it's not enforceable, that there are probably three quick points I'd just make. Is that first, that businesses should be aware that there might be reputational consequences if they do not follow the guidance. I think we've already seen in the context of companies taking advantage of furlough funding that not being in breach of the law per se is not necessarily a protection against negative publicity. Second, if you've got a clause which requires you to act reasonably, then courts may take the guidance into account when determining whether or not a party has acted reasonably. So what I mean by that, so if you've got a clause saying that you, in order to take a decision, you'll do so with a certain amount of reasonableness, if what you've actually taken is contrary to paragraph 15 of the guidance, the May guidance, and the examples that they give, a court might actually use that to construe that actually the party has acted unreasonably when dealing with its counterparty who's facing a COVID issue. And then the very final sort of third point I'd make is that obviously you need to remember that there are certain elements of disputes which are at a judge's discretion. And a key example of that is costs of the litigation. So when costs come to be determined, a judge might actually try and penalise you on costs because you've failed to follow the guidance, even though you've actually ultimately won the case. And there's no reported decisions, as far as I'm aware, about the guidance, but it's just certainly something to bear in mind. So very finally, in terms of alternatives to litigation and arbitration, I think, as we all know, litigation and arbitration, it can be expensive and time-consuming. There's also a factor of opportunity cost, as it will invariably eat into management time or your commercial colleagues' time that are involved in the dispute, which could probably be better spent invested in other matters trying to generate profits for the business. And so therefore you might actually, even though you have a clause which says that you have to, which gives you the option to refer a dispute to litigation or to arbitration, you might actually just want to consider whether there are alternatives to try and resolve that dispute without relying on litigation or arbitration. So say your commercial discussions have failed, options you could take is actually whether or not you reach out to the other side to see if they'd be interested in early stage ADR or mediation to try and resolve a dispute now without formal litigation. In the context of the pandemic, we're seeing that that's actually becoming more common for parties, mainly because the parties are aware of the backlogs in the English courts at the moment due to the lockdowns. And so therefore that there may be a delay to get justice. So they're seeing that actually if they can try and reach a settlement through early stage ADR or mediation now, it'd be better than trying to receive a judgment in 12 or 24 months' time. And within that, what I'd sort of encourage is obviously that parties be realistic when, if they're unable to reach a commercial dispute and the only option to try and resolve the dispute is through litigation or arbitration. Obviously, it can be better to try and reach compromise now rather than, say, 12 or 24 months' time. But another factor you might want to consider is actually that is around costs. So obviously, we incur costs, legal costs, in terms of paying for lawyers to prosecute litigation or arbitration. Whilst the general rule in the English courts is that the loser pays the winner's costs, there's always a certain element of that which is unrecoverable. So courts generally award 70, 80% of the legal costs that you incur. So actually consider whether actually, as part of any settlement discussions that you're having with the other side, whether or not you throw in that element of the wasted costs into the settlement discussion. So say, for example, it will cost £300,000 to take a matter to trial, and you sort of know that you're only going to get £200,000 back if you win the case. Just consider actually, is it worth using that £100,000 that should be the wasted cost element as part of your settlement discussions now? Very finally, Doug is just going to touch on how we might be able to help you.
As a top 50 firm, our national litigation team has over 150 litigation lawyers, and we are here to help, not just in terms of litigation, but as we've been talking about today, also to advise on general commercial risk management and how to avoid disputes within your particular sector, which includes us being very happy for you to bounce questions and issues off us, especially before they've turned into a formal dispute. In normal times, but also at the moment, we also offer what we call a defence counselling session, which would have been myself or Mark or one of our team spending an hour with you over a coffee, talking about the above on a one-to-one basis, or with your wider legal team and or commercial team and sales team. And it can be more tailored depending upon the risk areas of your organisation. We are still doing this and we're very happy to do this, although it would obviously be over Zoom, but please do get in touch if this would be of interest. We've got 4 minutes left where we are going to answer a couple of the questions. We've had quite a few in, so thank you very much. As I said at the outset, we will be following up after with any questions we haven't answered. But one here that I can see is where do you most often see disputes arising? obviously a fairly general question, but it's a fairly easy one to answer in that, on the whole, whilst a dispute will normally kick off during the lifetime of a contract or immediately after, the reality is that most of the time they are centered around either the very start of the relationship in terms of representations or drafting of the contract, or it's going to be you're arguing about a termination of a contract. So again, as we've been saying today, it's just so important to understand what the relationship is and what you're required to do. And then Mark, I think you're trying to pick up one of the questions as well.
I knew that would happen at least one time during this session, so apologies. There's a question just here about, is there any tension between contractually agreeing to arbitration and a university's charitable status? In short, I can't see why there would be any particular tension. All arbitration is a dispute resolution mechanism which parties contractually sign up to, rather than referring their disputes to court.
Actually, just one more here. There's one here. How would you inadvertently waive privilege? Quite easily is the answer to that. The starting point is understanding the different types of privilege and when they apply. But for an in-house lawyer, as I mentioned, you almost have two hats on. So when you are an in-house lawyer giving legal advice to the business, that will always be covered by legal advice privilege. However, if you are involved in more commercial decisions and operations and you haven't got your legal hat on, then that would not be covered by legal advice privilege. And if litigation is not in contemplation, then it wouldn't be covered by litigation privilege either. Another obvious one is whereby if there is potential litigation on the horizon where legal advice is distributed too widely within the organization, there is again a danger of waiving privilege. So on a practical level, we would always say that there are practical steps that you can take to try and increase the chances of privilege attaching to it, such as keeping the client group or the group of people receiving the advice to a limited number, marking it as confidential and legally privileged, but also, making sure that you don't, for example, forward on much longer email chains where it might have started off as legal advice, but it doesn't carry on as legal advice, or the other way around.
I think, Doug, just on that, I'd add as well, I've seen examples of where clients have gone and got legal advice, and then the commercial teams have actually referred to that legal advice in their correspondence with the other side of saying, we've sought legal advice and you're wrong because of X, Y, and Z.
Yeah, absolutely.
Unfortunately, later on.
Yeah, and board minutes is another classic as well, where advice can be, the privilege can be waived. So we are now at 10:45, so we hope that you found that helpful. The next in-house in focus event will be on the 27th of January, and it is an employment update also covering IR35. When you do log off from today, you'll receive a feedback poll. Please do complete that, which will be sent to you after the session. And thank you very much for joining us.